And on to the most important topic today, considerations in enforcing non-competes. If there are two takeaways that I want you to remember today, it's number one, the fees may not necessarily be worth it. Be very cautious about the cases that you bring. Secondly, the burden is on you. So remember, when you go ask a judge to put someone out of work, make sure to have the evidence all lined up. So get your evidentiary ducks in a row. Go do a forensic investigation, make sure you uncover all the stones that you can, and don't let the client dictate which evidence you look at. Once you've secured the evidence, preserve it, especially when you're dealing with emails. Make sure to go and get the server-side version of those emails. That way you make sure to get exactly what was sent and received and not what the employee didn't delete. Next, set realistic expectations for your client. That goes from what injunctive relief you can get, what monetary damages you can get, perhaps most importantly your fees, and certainly counterclaims. Next, a big one, determine what law applies. Now, we're in Texas where it's a little more employer favorable, but we touch Louisiana and Oklahoma, two states very hostile. It can be outcome determinative. Next, what about where to sue? Well, Texas will enforce mandatory venue provisions, but just remember, if you're going for that injunctive relief, there's extra venue provisions that may come into play there. Next, what about, are the restrictions enforceable? Well, that's the standard analysis. Is it ancillary to an otherwise enforceable agreement? Is there a protectable interest? Are the restrictions reasonable? Well, let's delve in a little bit to protectable interests. Confidential information, trade secrets, specialized trainings, that's going to get you there. What's not going to get you there most of the time is goodwill, unless it involves the sale of a company, even though there's a lot of case law suggesting that it will. What about temporal restrictions? 1 year is a really good rule of thumb, but generally, if you want to justify more, you got to show confidential information and customer relationships that justify that. Next, what about geographic restrictions? Rule of thumb, you can restrict the employee from the same geographic territories that they had before. If you're going to go beyond that, again, make sure you have confidential information or something that would justify those extended restrictions. What about the scope of activity? That's a little more complicated, and this is where most TROs and non-competes fail. You can get the same duties. That's going to take you where you need to be, but you may need to reform them, so just make sure that you know, make sure that you tell the client, if this needs to be reformed, you may not get money damages, and you may open the door to the other side getting their fees. And that's why it's important to look at what other claims are available. That may end up being the tail that wags the dog. Remember, you don't get attorney's fees for breach of contract claims, so hunt down those other claims where you do get them. So next, it's important to anticipate counterclaims. The best defense to a breach of contract claim is a breach of contract counterclaim. So just make sure you run the traps. Did they make were they paid all their commissions? Were they classified correctly, etc.? What about suing the new employer? Well, you may not have a choice depending on some areas that you're in. At least one court's held that they're a necessary party, but at the end of the day, that's where the money is. What about the actual TRO fight? Well, again, don't go into a court asking the judge to put someone out of work unless you have the evidence to back it up. Also, at the hearing, when you're dealing with imminent harm and irreparable injury, we're in Texas, we get some favorable presumptions, but those presumptions aren't absolute. You have to focus on that black hat evidence. A mere breach of contract is not enough to get you there. And finally, what about mediation? Well, the timing of mediation is everything in these cases. Most of these cases settle. So don't expect the other side to come and unload a bunch of money on the table for you unless you've bloodied them in the nose a little bit, or at least allowed them the opportunity to try and strike out your restrictions. So I know we don't have time for questions, so I'll just say good luck in finding that black hat evidence.